Property management is a specialized area of the real estate industry. Sometimes it requires a special licensing process, although in most cases, a broker's license will cover property management as well. But a property manager's license does not grant rights to act as a broker. Under certain circumstances, a property manager working for a licensed broker or working at a single facility for a landlord might not need to be licensed at all. But because this is all about real estate brokers, we'll focus on this from a broker's or brokerage's point of view. The property management agreement is a particularly important contract. While in most states a property manager owes fiduciary duties to their landlord-employer, there's far less in terms of required and standardized clauses. In fact, the property management agreement pretty much outlines the entirety of the obligations associated with the contract. A property management agreement has little limit outside of the law. That is one more reason to consult a real estate lawyer as the best practice in this case, unless you have extensive experience on your own in which you have full professional confidence. Consultation with an attorney is recommended to review the contract or to draft one for you so that all parties understand exactly what the contract entails. So, what items are included in a property management agreement? Any number of items need to be taken into consideration. For example, what specific duties are requested? Who will hold the security deposits? Will there be employees, or who will handle maintenance issues? None of these are given or presumed and must be included in the property management agreement if they're to be performed. Another key concern in property management is how maintenance is handled. This will vary from agreement to agreement because each job is truly different. Managing multiple single-family dwellings versus one mid-sized multi-unit versus many mega units, the needs are not going to be the same. Maintenance issues can be managed many ways, the most common being, in smaller locations, the property manager or the owner handle it themselves. The property manager can hire help as needed. Independent contractor service providers can be on call or regularly scheduled to perform maintenance, or in the larger complexes, maintenance staff can be hired. This leads us to the client trust accounts and client security trust deposit accounts. Client trust accounts create some of the most sensitive, potentially problematic duties. One client trust account may be used for all clients with individual ledgers, or a separate client trust account can be kept for each landlord-owner. Client trust accounts generally must be reconciled once a month, more often if specified in the property management agreement. The business's funds or the individual broker personal funds cannot be mixed with the client trust funds. This is a violation called commingling. And one client trust funds cannot be used for anything except that client. Using them for personal reasons, business reasons, or covering another client with the intent of replacing the funds as soon as possible is a violation referred to as conversion. Client funds must be used exclusively for the client to whom they belong. Finally, one last point regarding client trust accounts. These can be interest-bearing or not, depending on your state or local laws. But then when they're allowed, they generally require written notice signed in advance with an explanation of where the funds are being kept, who receives the interest, and when they receive it.